Home improvement. Hey, you get a building permit and you're off and running, right? Well, let's take a look at this week's case. Involved a real man, Michael Davies. He's in Massachusetts, bought a home in 2006, wanted to do some minor repairs to it and do some improvement. What he wanted to do was remodel the kitchen, remodel the bathroom, change an exterior door, change the way in which the roof was angled. It was a very small property. He estimated the total amount necessary to do all of these improvements was going to be about $10,000 and take one weekend. Well, in front of the house was another couple, and the property was such that Michael's house was behind the house owned by a couple named Stanley and Susan Cox. Well, Stanley and Susan Cox didn't want to have this improvement made to this house that was behind their property. So they objected. Now, the Hingham zoning department had granted a building permit to Michael, and Michael was all set to get going. The Coxes, along with another neighbor, said we don't want to have that happen, and they appealed. It went up to, in fact, a court. And there a judge had to determine whether or not to allow the building permit to exist and whether or not to allow Michael to go forward with his home improvements. Now, the arguments that were made on behalf of the Coxes were, one, we don't know when that house was built in 1948 whether it was built according to code. Two, we think the house was abandoned. We don't think anybody has lived there for over 2 years, and accordingly, we think it's abandoned, and therefore, in order to have any kind of improvement done to an abandoned property, you need a special use permit, you need a building variance. Well, Michael, on his behalf, argued through his attorneys that, wait a second, that house has been there since 1948. Here we are, I'm trying to do this work in 2016, and it's been grandfathered in. It's been grandfathered in. Two, for all intents and purposes, this is just a small amount of work that I'm doing, a small amount of work, or what the law will refer to as a de minimis amount of work, and therefore it's not a big deal. And as to the apartment and the building being actually abandoned, well, sure, I'm renting it to a tenant, want to rent it to a tenant. It hasn't been abandoned. Sure, the people that owned it before I did were not living there, and in this instance, I haven't had anybody living there since I purchased it, but I regularly go in, I maintain it, take care of it. I'm looking actively for a tenant. Once I can get some water back there, and now this takes us to another backstory on this whole thing, the Coxes actually controlled the water main that ran to the property in back of theirs. They had turned off the water to the property, therefore no one was able to live there. Michael was in the process of getting a water main that was going to run along an easement to the property. Well, anyway, he said, I'm actively utilizing the property. It's not abandoned. So the court had to hear these various arguments. The court heard these arguments and at the end of the day found in favor of Michael, found in favor of Michael because the court said, we agree that in this instance, that house was built in 1948. We don't know whether it was built according to code at that time. All the records have been lost, can't be located, but it's been there for all of this time. It's grandfathered in. As to the property being abandoned, well, in order to show that a property, particularly a residential property, is abandoned, you have to show more than the fact that somebody's not living there. You have to show that it has not been in any way maintained or repaired, or that the owner is not actively looking for occupants. In this instance, Michael has maintained the property. He goes there on a regular basis, takes care of it, and he is looking for a tenant for that property. All of this being considered, the court came away and said, I find in favor of Michael, and I find that, in fact, he can engage in his home improvement. So what do we learn from this? We learn an important thing from this. One is that when somebody gets a building permit in your community, if you are an interested party living in the neighborhood, you have a right to object. That two, if that objection is not upheld by the zoning board, you have a right to appeal that to a court. Now, in this instance, the court, as we saw, needs to consider the evidence, and here we saw that they found in favor of allowing that permit to go forward and allowing Michael to engage in his home improvement. All right, bringing this case, we're bringing cases every week so you understand how the law works. I'm David Allen.